Hi guys, Hayder here from Justice Family Lawyers, here to talk today about a very serious issue about child custody. What happens to the children when the two parents separate? Now in Australia, there is no default position as to whether a child will go with the mother or the father. The default position is that the courts must determine what is in the best interest of the child. Now, if the mum and dad can't figure out what is best for their child, or they can't agree on that, which is quite often the case, and that's why they go and see their family lawyers to figure out what should be happening in this situation, then the courts need to intervene and make a decision about the children of a relationship to determine as to whether or not they should be living with one parent, should be spending extra time with another parent, and on what basis this should occur. Now, they do this by going through a series of different checklists which are in the legislation, which determine where the children will live and who they'll spend time with. Now, you can have a lot of different arrangements with children. Some arrangements may look like a 50-50 arrangement. For example, 1 week with mum, 1 week with dad. Some arrangements might mean that they may live predominantly with one parent, for example, mother, for 9 nights or 10 nights or 11 nights out of a fortnight, and the dad might see the children on an alternate weekend or maybe a few nights during the week. Basically, if two parents can come up with an agreement that they think is going to be best for the children, then more often than not, the courts will say that is a good idea. The courts need to look at a number of different factors in order to determine whether or not an equal time arrangement for a child is a good thing for that child. There is no default position. It could be either living with the mother or living with the father. Now, when you are able to come to an arrangement, you may want to document that arrangement so that it's formalized and so that there is no confusion in the future. The best way to do that is by formalizing it by way of an application for consent orders. What that means is you fill out a document and that gets submitted to the court with the arrangement that you and your partner or ex-partner want for the children. Now, when that gets submitted to the court, somebody at the court does review it to ensure that this arrangement is workable and is good for the child. Then it gets approved and you get a seal on the court documents. Once you get that seal on the court documents, you then have a set of orders which are enforceable under law. Now, it's important that you get such a document and you don't just have a verbal agreement or an informal written agreement, because often there is misunderstandings that occur. Sometimes there could be some technical issues. For example, what's going to happen with school holiday time? What's going to happen on Father's Day? What's going to happen on the children's birthdays? So if these things have already been canvassed at the beginning of this arrangement, then often you will avoid the unnecessary conflict that can occur with miscommunication. Now, if you speak to a family lawyer, speak to a family mediator or a counsellor, they can prompt you to think about these things. It's things that they think about daily, and it's things that they often used to making arrangements for separated couples. So have a think about it. If you have any questions, please let us know.